I got the recording, so they recorded the whole thing.
Before we go on the record, who do we have? We have Mr. Moscato for the company, Mr. Goodman for the Department of Public Service, Mr. Twitchell, Ms. Riggle, Mr. Riggle. Who else is signed up on the party list? I do have a...
Tina Graziano.
Yes, is Ms. Graziano here? Okay, you don't need to speak other than to say your name.
Mr. Lecakes, could you check and see if mine went through? Patricia Greenstein? Because I put it in late this afternoon, I'm not sure if it went through.
The information I have is from this morning. I left my office approximately noon, but no, Ms. Greenstein, you can come forward or you can stay there if you'd like. If you're going to stay there, let me give you a microphone though so that you can speak. And all you'll need to do is just identify yourself. I will take a representation that you made a request for party status, and I will put that through. If it did not go through today, I will put it through tomorrow. What we're going to do is we're going to go onto the record, and then I'm just going to go around the room and have everyone identify themselves who's on the party list. And then at that point, I'm just going to initiate a conversation with the different parties, basically to try and find out what people feel there needs to be considered in this case and how that should be done. I do not expect to make any rulings on process tonight. I will have a written ruling that will be posted to DMN hopefully within the week, although that's not completely in my control. Even if I get it finished timely, other people control when those things get issued. So, Howard, let's go on the record. Good evening, everyone. We are here for case 18E-0399. This is the petition of Cassadaga Wind LLC for a certificate of public convenience and necessity pursuant to Section 68 of the Public Service Law. This case was initiated by the filing of a petition of Cassadaga Wind LLC. Just to recap briefly what we said at the public statement hearing before this, there was a siting board order that was issued in January of 2018, which granted Cassadaga Wind LLC a certificate of environmental compatibility and public need under Article 10 of the Public Service Law. Essentially what that did was that provided a conditional certificate to Cassadaga Wind LLC to proceed with plans to construct a wind farm that they had proposed in the local Cassadaga, Arkwright, Silver Creek, Cherry Creek area. And as part of that order, the siting board debated whether its action superseded any commission action in granting a CPCN to Cassadaga Wind by the commission. Ultimately, the siting board determined that the commission considered matters that were different than what the siting board did, in particular the financial viability of the company to construct the wind farm, and it ultimately provided the authority to, or recognized the authority of the commission to issue a Section 68 CPCN if it found, if it made the proper findings under the Public Service Law. Why don't we start by going around the room? We'll start with the company and just identify yourself for the record, please.
Thank you. Good evening, Your Honor and Commissioner Berman. My name is Jim Moscato from the law firm of Young Summer, representing the applicant, Cassadaga Wind LLC. And with me tonight, Your Honors, just for your information, I have Chip Redling, Senior Director of Business Development with Inogy Renewables.
Thank you.
Jay Goodman, Assistant Counsel for the New York State Department of Public Service.
Thank you, Mr. Goodman.
I'm Tina Graziano. I'm party to the case.
Thank you, Ms. Graziano. And you're a local resident as well?
Yes, Mark Twitchell for the owner party to the case.
I'm Joni Riggle, party to the case and representing concerned citizens.
For the record, that was Joni, Joni Riggle.
Hello, I'm Earl Riggle, local resident, party to the case.
Thank you. And in the back?
Patricia Greenstein, party holder, live in the town of Charlotte.
Okay, thank you very much. So, when we held the public statement hearing earlier, I tried to explain a little bit more about what this process involves. And again, the last person who spoke at the public statement hearing tried to explain that, in her opinion, it didn't matter, the date of January didn't matter, and that, you know, the commission should reconsider. I do want to point out that the reason the January 18th date was important is not because of when it occurred or that things are set in stone. It's that that was done by a different political body. It was done by the New York State Board on Electric Generation Siting as opposed to the Public Service Commission. And the way that the laws interact with each other, the commission doesn't have the right to override the determinations that the New York State Siting Board made. It can make its own individual determinations on things like the financial viability of the company to go and ahead and construct the facility, but it doesn't have the right under the law to revisit the decisions that were made by the Siting Board. Mr. Moscato, Mr. Goodman, do you have any issue with anything that I just said? Do you have any agreement or disagreement with anything that I said about the scope, my understanding of the scope of this petition?
No, Your Honor, that's consistent with our reading of the Siting Board's decision in the Cassadaga proceeding, and so we would agree with the narrow scope of this proceeding.
Okay, and Mr. Goodman?
I think you fairly summarized the scope of the proceeding as it's set out under the certificate of order.
Okay, yeah, thank you. Okay, so with that in mind, Ms. Riggle and the other residents, although I believe Ms. Riggle is probably best qualified at this point to speak on this because I think she's done the most research. You filed comments in July of this year, several of which went, I think, to the corporate structure of EverPower. Actually, before I turn to you, Mr. Moscato, the company filed for a petition for a declaratory ruling that was granted in July by the Public Service Commission that involved the transfer of ownership. Has that transfer of ownership taken place? What is the corporate structure right now?
Yes, that after the declaratory ruling was issued, the transaction took place, and currently the corporate owners of Cassadaga Wind LLC would be Trireme Development 3, which is the holding company that was sold by EverPower to Inogy Renewables US. And so immediately above TED 3 would be Inogy Renewables US, and then above Inogy Renewables US is Inogy SE, which is the publicly traded company on the German stock exchange.
Okay, and so the Terra Firma group is completely out of the corporate ownership now?
Correct. Terra Firma was the upstream owner of EverPower, and so Terra Firma sold its assets and is no longer in the corporate structure.
Okay, so as far as I understand it, Ms. Riggle, all the comments that were made about that group are no longer involved in this case.
We would like to see documentation of that. That's really confusing. Who's Inogy's upstream?
So, Your Honor, if it's worth clarification,
Yeah.
Inogy Renewables US, the upstream parent is Inogy SE. It's the German company that's publicly traded on the German stock exchange. This information is no different than the information that was in the petition that was provided to the commission in this case.
Right, I'm specifically speaking, Ms. Riggle, and I'm not discounting the entire comments, just the one section. I just want to clarify what we're all discussing here. And it goes to the terra firma ownership group and the capital partners, specifically headed by Guy Hands in the UK.
Well, if they're truly, I don't understand, Trirene's parent, they were under terra firma, I believe. So why are they still listed as in this hierarchy right now? I don't understand Ted. Why is Ted still involved? Because that was under terra firma's, under the auspice of terra firma.
Is it because the companies still exist but were sold to Inogy?
Correct.
Okay.
That's
But,
correct.
you know, the points I made tonight about RWE and Eon, those are very relevant because Inogy and the Inogy SE and Inogy US are subsidiaries of, these are the huge parent companies. They're like the Enron of the US. I mean, it's totally relevant what's going on there. And that's why I believe we need to have an evidentiary hearing because you sure glossed over that. I mean, that's a critical issue. I have so much documentation here on what's going on in the German energy market.
Ms. Riggle, before we get to that, all I was trying to do is clarify that, no, it's fine. I understand completely. I'm just trying to get the corporate structure so we're all on the same page about what we're talking about. So Mr. Hands and Terra Firma are no longer a part of this.
Right.
We haven't gotten to Eon or RWE yet.
So I would like to just say, if I could, Your Honor, like, I don't understand why this isn't public knowledge, any of this, all these transactions going on. There can be no vetting or scrutiny. We're party members, and that should be on the docket, and you tried to waive this public hearing. We didn't even know about it. And just all these, you keep changing the case numbers for PSL 70, PSL 68, we stumble across it, and that's not right. We are party members, we live here, we're the community. That will be impacted, and it's just wrong.
They have no control over the case numbers. Those are assigned as the petitions are filed by the Department of Public Service. And so they come in and somebody does a review of that and says, okay, this is a different case, it's seeking different authority. And so, especially with regard to the petitions that were filed recently, because those are considered by the commission, they're not considered by the citing board, and so it can't stay under that 14F0490 number because it's a completely different deliberative body that's considering those. So that's why that gets, but that's a completely different issue than the issue of who gets served for those new cases. And so I can say, Mr. Moscato, that I do agree that parties that were active participants in the Cassadaga Wind Siting Board case should be getting notified of these new petitions as they're filed, and I would appreciate that happening going forward if it hasn't happened already.
Yes, so notice was published pursuant to the Commission's regulations, and notice was provided to the participants in the Article 10 proceeding, as well as a notice was posted on the Article 10 project DMM page. The parties received electronic notification pursuant to that notice. In the future, sorry, Your Honor, with respect to in the future, if there were additional notifications or filings that were required, we would submit those on both dockets if it was helpful in that regard.
I would appreciate the listing of that number, but I would also appreciate if the company would make an effort to, there were obviously several individual residents of concerned citizens for Cassadaga that participated at the hearings. They were here every day for the evidentiary hearings. They're here tonight. If we just take this core group right now of the people that are here that have been identified as residents on the party list, if you could make sure that you have their email addresses or however they prefer to be notified, if it's regular mail, their mailing addresses, and just continue to email them if a new petition is filed, if a new compliance filing is filed, something like that. I too get those DMM emails, and sometimes it's very hard to track them because they come in and sometimes they're just to notify the new comment or something has been filed. And so when something like a petition is filed or something like that, I would appreciate if you would provide direct notice of that new petition, that new case that's being started to those active participants.
Thank you, Your Honor, and do you think I think it should be cross-referenced on the main case record. I don't know why. I've talked to Andrea about that, and she said it really should be cross-referenced, and that's what I'd like to see, and then more, public that are following our Cassadaga Wind project could be made aware.
And Ms. Riggle, again, that is not something that's in the control of the company. Excuse me.
That couldn't be posted
Of the
as a
company.
comment?
Well, I don't know. I can find out if it can be or how that works. But there are certain rules in the way they administer DMM, and sometimes they're very quirky. And I will look into that though personally.
Thank you, because it was done after I found the PSL 70 on a news case number. I called Mrs. Servin, and she did have them. I saw quite immediately they did post it on our docket, so I know it can be done. So I would appreciate that. Thank you.
Right. Now, let's go back to the parent company structure. And Mr. Muscat, I'll give you an opportunity to address this, but Ms. Riggle, and anyone else of the residents who wants to chime in on this, Ms. Riggle, why do you feel that the parent company structure and the viability or even the organization of those companies is relevant to the consideration of whether Cassadaga Wind itself, LLC, has the financial wherewithal to construct the project?
I would say that they look like they're going through a major transition, and I have a lot of documentation here of their $1.47 billion US loss in the first quarter. Inogy, according to Inogy, their first quarter earnings before profit and taxes fell by 2%, which is $1.47 billion US. And it just talks about a lot of losses. Falling profits and heavy customer losses were added to the woes of embattled Germany renewable energy provider Inogy during the first quarter of 2018. And just a lot of things like that. Minus 41%. Their profit dropped minus 41%. Upon acquisition of the Cassadaga Wind project, Inogy US as upstream parent would likely be the source of some or all of the necessary financing. They have not made it at all clear what the financing is going to entail here. Is it investors? Is it? I think I read in my statement the list of sources of revenue for this project, but it just sounds so nebulous and vague. We want to see the actual, that you have
Yes, and further, Your Honor, and
yes,
Commissioner Berman, very related to the financial integrity of the parent company is the issue of turbine safety, because if this is an underfunded corporation, they are very likely to have issues with maintenance, which result in a high percentage of accidents which were not discussed in the evidentiary hearing and were not reflected in a recommended decision.
Right. So this is an interesting point, because I think here you've picked up on something that I do think is separate and apart from the siting board order, which goes to okay, so as I understand the siting board order, it found that with the conditions imposed on Cassadaga Wind LLC, that it generally found that the project would be safely operated. However, I think the issue that you just brought up here goes to the specific ability, financial ability of Cassadaga Wind LLC to maintain the turbines during the 20-year lifespan or whatever the lifespan is of this project. Is that right?
That's very correct.
All right. Mr. Moscato, do you agree that that would be something that would be before the Public Service Commission, is the ability to finance maintenance costs during the life of the project?
Well, I'm not certain, Your Honor. That may be something that's within the purview of the commission, but it may not be within the purview of the commission in this proceeding. To the extent that there's some future financing for the project for maintenance-related items, that may fall under the purview of Section 69, for example. With respect to this proceeding, I know the issue of decommissioning and other financial commitments that the company's made in the Article 10 process came up tonight, and those are addressed with financial mechanisms that are required to be put in place as part of a compliance condition of the Article 10 certificate order. So we would anticipate that those obligations would be within the purview of the siting board, as they are compliance-related matters for the facility.
Right, I definitely agree with decommissioning. There was a large section, both in the recommended decision and in the siting board order, that went to decommissioning, and I believe that it was much stronger than the company had been looking for at the time. So I do agree that the siting board took the issue of decommissioning very seriously and did make actual findings on that, and then made certificate conditions related to that. So I don't think that decommissioning is a part of this. All right, I'll have to take a look at Public Service Law, Section 69.
One thing I would add to Your Honor is that with respect to maintenance, ongoing maintenance or inspections, those protocols, some inspection protocols are set forth in the Article 10 order. With respect to maintenance, turbine manuals and other information with respect to maintenance cycles is provided in the Article 10 order. I believe all of that will fall within the purview of DPS staff on an ongoing basis in terms of enforcement and compliance with the conditions in the certificate order.
I absolutely agree with that. I think that Mr. Twitchell was getting to one real nuance of that, which is that the look here is not just the financial viability or the ability of Cassadaga Wind to finance the construction of the project, but it's also to operate and maintain that project during its lifespan.
Right.
So I think it's just that twist on the finances aren't just about whether you can put the windmills off, it's whether you can put the windmills off and continue to maintain them and make sure that they operate safely during the length of the project and continue to meet those certificate conditions imposed by the siting board.
And I would say there's two things with respect to that. The company that's sponsoring the project has a long track record of being able to finance and develop these projects, both in Europe as well as a development pipeline in the United States. That's not going to change. I mean, quite frankly, I'm not certain it's within the Commission's purview, whether it's a multi-billion-dollar company or something less, to decide whether or not that company's going to make the required investment into maintenance of a facility. But the point here, so I don't believe that's within the Commission's purview to make those judgments, but instead is to look at the record that we've submitted as part of our petition and to be able to make the determination that, yes, this is an organization that has financial backing behind it, and it also has a contract to sell the energy. And so presumably it's in their interest to maintain that project, to keep that project operating. And that's the commitment that would be extended throughout the project. So one, it's not only financially viable, the corporate entities are financially viable, but two, the contract structure is such that there's a real feasibility in continuing the operation of the project.
Mr. Goodman, has DPS sent out any IRs, any discovery to the company on this case?
In this case, I don't recall sending out any discovery relating to the financial capability of the company. Just if I could go back for a moment, one, just to clarify, Public Service Law Section 69, which was mentioned, is for regulated entities like electric corporations like Cassadaga. They have to petition the Commission for approval to take on certain kinds of debt. For example, debt that will take longer than 12 months to repay. So I think to the extent that that was mentioned, it could be a bit of a catch-22 in that if you're looking at the financial capability of the company to undertake the project, you'd have to look at a snapshot of the company now. But if we start considering what might happen in the future with financing, that's a different question. We really can't.
Right. No, I agree with that. Although the snapshot now, do you agree, could be helpful as to whether the company is in a position that it would be able to obtain debt at reasonable cost. Well, I don't know that we need to get into reasonable cost because it's a wholesale generator, but that the company would be in a position to be able to obtain debt should it need to perform maintenance in the future, even though we can't necessarily know what's going to happen, 5 or 6 years down the road.
Yes, I suppose if the question is just making a determination that the company can acquire debt that might be needed to finance the project, I see that would be relevant to the question, does the company have the financial wherewithal? I'll also just note, though, that since the market in New York State deregulated and we had the emergence of independent power producers, like Cassadaga or Dunkirk earlier was mentioned, for example, these are what are called merchant generators, companies that have assumed all of the risk of operation, so shifted the market risk from customers to merchants to the generator. And since that happened, when we have a company that has assumed that risk, the commission years ago made a determination that it needed a lower level of review to make these determinations than it would for a fully regulated company like Mohawk or Connex, because customers don't bear the risk.
But it still does do some review of those. The company still needs to make an application to the commission for approval. Is that right?
That's correct. I don't mean to say that there's no need for review or no need for an application. I am just trying to say that the review that is done is not the deep dive that would be done with a fully regulated utility, where it would be pouring over books and really taking a very hard look at the accounting.
You are working with accounting staff, I assume, Mr. Goodman?
Yes, Your Honor.
Have you had an opportunity to speak to Ms. Riggle and the other residents that are here tonight?
No, I have not.
I would appreciate if you would talk to them afterwards, give them your contact information. Ms. Riggle, the way the Department of Public staff works is that it has different offices that get assigned personnel when petitions like this are filed. And so Mr. Goodman interacts with a lot of accountants and a lot of engineers. I wouldn't know right now who is on this list because this is a different type of case, but he can tell you who those people are, what they're looking at during the proceeding. Do you know if any of those accountants or anybody else on staff has conducted any informal discovery, any phone calls to the company?
I don't believe that there's been informal discovery on it, but I'm not positive as to whether there's been any informal call. I don't know for certain there's been no informal conversation between technical staff and someone from the company. I don't believe so, but I'm not absolutely certain.
Commissioner Scott, do you know if...
I'm not aware of it.
Okay. Memories of July afternoon, is that noon?
And Your Honor, I would be happy, sorry, can I be heard well enough without the microphone?
Yes.
I'm not going to use the microphone.
The microphone right in front of you works for the court reporter. I can hear you fine, and so I'm sure that's picking you up.
I would be happy to talk to you after the conference is just suggested and provide my contact information. If you want to talk after tonight as well, that would be fine also.
I think it would be very helpful for the resident parties in this case to know exactly what documentation the accounting staff normally looks at in a Section 68 review, and if those documents could be provided to Ms. Riggle and the rest of the residential parties as the review is being done by staff, and even if there was somebody that could speak to them and explain to them, what they're looking at in those documents, to the extent that they're not filed confidentially. Is there any confidential information to your knowledge, Mr. Moscato?
No, not now, Your Honor.
Okay. If there is, I would need to make an order for that to give them access, and I don't have a problem with them having confidential access. process, they proved in the Article 10 process that they've been able to abide by, the rules and regulations that of these proceedings.
And right now, Your Honor, my understanding is it would be publicly available information.
Okay, thank you. Did we discuss the parent company and why you don't feel it's relevant here?
I didn't suggest it wasn't relevant, Your Honor. I just suggested, I explained who the parent companies were, to the extent that, Cassadaga Wind in the Section 68 petition is relying on the wherewithal of the parent entity. I understand the relevance of that and agree, and that's why we've provided that information.
Okay.
The other thing I would add, too, is that one of the concerns that was raised by the citizens group was potential for future transactions that may take place. And again, with respect to that, and Mr. Goodman referred to wholesale electric generators and the Commission's lightened regulation with respect to those generators, that precedent would also apply to transactions. That's going to fall under a different subsection of the Public Service Law. But I want to reiterate that that review would be required to be conducted if those transactions were to take place, to ensure that any future owner is also going to have the same financial commitments and have the same financial ability that the corporate parents do now.
Right. So, Ms. Riggle, the other case that you referenced before that got assigned a completely different number, and I didn't write this one down, 18E0333.
PSC.
So that was a petition for a declaratory ruling, and in just very basic layman's terms, what the company was saying was the commission either didn't need to look at this because it was something that the commission didn't need to look at, this transaction, or if it did look at it, because it is not a fully regulated entity like a Niagara Mohawk or a National Fuel Gas or a New York State Electric and Gas Company, since it's not a fully regulated entity like one of those utilities, then the commission only needed to look at it in a much lightened review. They didn't get as deep into the books because their costs weren't being sent to ratepayers who are captive.
Right.
And so the commission, what they did in this ruling that they issued on July 17, 2018, is they said, no, we disagree with you that we don't look at this, but yes, we do agree with you that it falls under this less of a intensive look at it. If I understand what Mr. Moscato is saying to me right now is if any further upstream, higher parent transactions took place, they would be required to file another Section 70 petition, Public Service Law Section 70 petition, like that one, and it would still have to go before the commission, although it would be, due to this precedent, a lightened look at that transaction. Is that correct, Mr. Moscato?
Correct. For a transaction involving Inogy Renewables US, correct.
Okay.
That was the entity involved in the 18E0333.
And Your Honor, if I may clarify one point, you said that there may be determination that no review is needed. I just want to say that whether there's a declaratory ruling issue, as there was in that case, or a determination made that a deeper review, more comprehensive review is needed and go through an order. In either case, the commission is conducting a review. When we get the petitions, there would never be an instance where the commission would say, we're not going to look at this and just approve it. The difference in the declaratory ruling is it's more cursory and a look at whether there's a potential harm to customers or a potential risk of market power, which also could harm customers. And if it fits within the precedent and there's a finding that there would be no harm to customers through either some rate impact or the market, then we can go through the declaratory ruling process. It's a long-winded way of just trying to clarify that, I don't want anyone to get the impression that these petitions might be filed and the commission will say, we don't need to take any look at it. You can go ahead and approve it. With the independent generators, we also occasionally get petitions asking for a declaratory ruling that the entity won't be subject to the new owner might not be subject to regulation because it's passive investment. But even there, the commission is taking a look to confirm that the interpretation of the law presented by the petitioner is correct, that there is a legal reason why no regulation of some minority owner is needed.
Right, no, I appreciate that clarification of my remarks, because that's absolutely accurate. Is whenever a petition is filed, even if it's saying, Public Service Commission, you don't have to even look at this transaction. They're looking at that petition to make sure that the statement of facts that the petitioner has made is accurate. So I do appreciate that.
Your Honor, could I?
Yes, you may. If you push it up, it's on.
Well, we're just lay people. We're trying to understand all this. All I know is there's a lot going on with the parent company, RWE and Eon and Inogy, and Inogy looks like it's going to dissolve within like a year or two. And there's all kinds of, top stories in the European energy market about what's going to happen here with Inogy, and if that dissolves, RWE is going to go bankrupt, and to me that is relevant. And we live here, and if they're going to be flipping these LLCs around and having different parent companies all the time, I just question. We've seen, what was it, out of the list, Noble Wind went bankrupt. There's so many bankruptcies. All these solar companies are going tanking, and the PTCs are running out. That's what this is all about. That's why they're pushing for that CPCN to get through so they can start their tree cutting, and that's a whole nother issue. They are not taking down our trees till they have proved their compliance. We live here, and that noise study hasn't been done. You haven't selected the turbine model, and all those compliance, it's the cart before the horse. All those compliance conditions should be met, because this project was approved for construction, but not, what's the wording I'm looking? I'm really tired. This has been really stressful, and I think you need to know 2 years of our lives have been fighting this, and we just want to retire. We want to enjoy our lives, and we've seen what's gone on in Arkwright, and it's very difficult to wrap our brains. I've spent hours researching this company. Inogy has no history in the U.S. They've bought all the pipelines to develop, but they don't have any history here of any success developing. What goes on in Europe, that's totally different. I think that, they have no history here, so how do we know what's going to happen?
Well, it's relevant, though, what goes on in Europe, in the sense that it demonstrates a successful ability to build and to proceed with the construction and get a project in place. I do agree that it's not necessarily in the U.S. jurisdiction, but it is relevant information that the Commission should be considering. Mr. Moscato, do you have anything?
I mean, I would add to that, Your Honor. Again, as we've set forth in our petition, we're talking about an entity with investment-grade qualifications. It has over $1 billion of assets and a portfolio of developed projects in Europe, of operating assets in Europe, as well as development projects in the United States. And so with respect to some of the speculation, I can understand the questions about the process, and I can understand the questions about what the scope of the review is. But I don't believe that those questions and the speculation surrounding those questions would necessarily rise to the level of something that is an issue of fact for the Commission to determine in this proceeding.
Yeah, I wasn't able to determine, but maybe you were, the source of some of the speculative comments that were made. Are those financial analyst reports? What are those that are in Ms. Riggle's comments? Do you know?
I don't know, Your Honor. I think some of it's news stories. I'm sure Ms. Riggle may be the better person to ask the question, but it's not. I think it's some news stories. I think it may be some analyst reports. I mean, there's a lot of. You don't have to go to Europe to find speculation about publicly traded energy companies and what may be happening, forecasting their futures. So I think that's mostly what it was involving. There is a transaction involving RWE and Eon. That's something that hasn't been consummated yet. It's been announced, but the transaction is not intended to be consummated until next year. And, I think the best explanation of that is you have billions of dollars of assets with one entity and billions of dollars of assets with another entity. Regardless of whether Inogy's under the Eon umbrella or the RWE umbrella, in the potential market power issues that appeared to be mostly in what was Ms. Riggle's submission about what this would mean to power markets in Europe. For our purposes, these would be billion-dollar entities that still are the parent companies of Inogy and Cassadaga Wind LLC.
Right, I do know that while Ms. Riggle pointed out that there was a percentage decline of profits, even in the article that you cited, it mentioned that.
These are stock market reports.
Okay, so stock market financial analyst reports.
Financial analysts.
We'll get to that in a second. It did mention that Inogy on Monday reported an adjusted net profit of 610 million euros, which is at the time of the article was written approximately $731 million. So it's still making a net profit of $731 million US dollars for the 3 months, March 31st, down 11% from a year earlier, but that's still $731 million US dollars as a net profit.
Yes, Your Honor, I understand your point. However, the issue of financial integrity, it hasn't been addressed to the issue of turbine safety, not in the evidentiary hearings at least, because no matter how strong these corporations are, they internationally and domestically they have a very poor record on turbine safety, and this was not brought up. The number of turbine fires, turbine blade throw incidents, and structural collapses was never discussed as a quantitative measure.
Mr. Moscato, is there publicly available information that could be provided that demonstrates maybe a 1 to 3 year average for other wind farms that are owned by one of the subsidiaries or sibling companies of Cassadaga Wind LLC that shows like the maintenance costs and operating costs per year, at least at a very generic level or sky high level?
Well, Your Honor, I mean that's a complicated question because the maintenance, in terms of across a fleet of turbines, it's going to vary from project to project depending upon a lot of variables. With respect to Inogy specifically, I don't know the answer to the question. There may be some information that was provided as part of the Article 10 submission on maintenance or future costs and upgrades. But we could provide that information. A typical U.S. market number we could provide.
That would really, I would appreciate that if you could provide that to my attention to Mr. Goodman as well as to the residential parties.
Your Honor, just so can I understand better what you're looking for in particular? Is it just an industry average of maintenance costs for an operating wind farm project?
Yeah, and if you could, in the regulated utility world, we would call it a normalizing adjustment, but projected or adjusted to basically, so provide the raw numbers, but also try to put that in the scope of what Cassadaga has proposed here, which is the number of turbines.
Right.
So that would be appreciated because I know it would vary on topography as well as number of turbines and other
Usually
things.
turbines, right? It is going to be, I think, a variable number, but if the intent here is to provide a ballpark maintenance number for a comparison to the assets of the company, I think we could do that.
Right, and I wouldn't hold it as hard evidence of what those costs would be, just to get an idea of what it looks like based on other wind farms to hear.
And Your Honor, I think you mentioned, or maybe it was Mr. Moscato, if the information for the Cassadaga project specifically was provided in the Article 10, it would be helpful for that to be called out and provided also.
Yeah.
So I would heard discussion of the industry average in comparison, but if that project-specific information is available, it would be easier than trying to dig through the record.
Right, I understand that. Mr. Moscato, what Mr. Goodman is saying is if it is in the Article 10 application that Cassadaga Wind LLC filed, or at least if projection costs are there, if you could just let us know what exhibit it's in, and even provided it, or at least those pages of the exhibits.
My guess would be it's in Exhibit 14, if it's provided at all. But we can double check that. And I would also say, if we can provide the information from the Cassadaga application, my preference would be to provide that rather than the typical number, because I think it's going to be far more meaningful.
Yeah, I agree. I absolutely agree. And then, any, it needs to be updated based on 2018 costs or something like that. I'd appreciate that as well.
Your
Thank you.
Honor, oh, go ahead. Mr. Lecakes?
Yes. I can hear you.
Oh, okay, I got a pretty loud voice. Mr. Goodman made some, I just want you to clarify something for me, and then I'll let you know. Mr. Goodman just stated that for private companies, they're not fully regulated, there's less scrutiny by the PSC, is that correct?
Yes.
Okay? And then you also talked about harm to customers. And my question is to you, which is, I'm not sure what you consider which constitutes harm. I'm not sure if you mean financially. But when I'm listening to everybody up here, we're talking about, this company being solvent and being able to financially carry out this project. We skipped over some things. We went through the Article 10. And a lot of it came up tonight with comments from people from various areas in the community about damage and loss. If a business is doing a business statement, they have their profits. But if they damage somebody, say I've got a roofing company, and I damage somebody's house, I have to have insurance to pay for damages if my workers mess something up. We've never even discussed about the damages and loss, and you're talking about harm. I'm not sure if I'm making any sense here, but what is going to happen when, and it was never covered in the original process, in the original hearings, about who's going to cover damage and losses when somebody like me, for instance, only is going to get 50% of the assessed value of my home, and I have to vacate my premises because I can no longer sleep there. And you've heard from people in the audience that that's happened. It's happened across the state. And so when people like Mr. Moscato are representing these LLCs, we just hear these glowing profits, $250 billion, whatever, but we never ever hear they're managed to hide anybody who's filed lawsuits, whose homes they had to buy out. In place right now with this Article 10, we're the first Article 10, in the mitigation, when we talked about mitigation, was a word that was discussed through this whole process. I'm not a legal person, but mitigation means to me that you're going to do everything that you possibly can to make sure that nobody is harmed by this, and that if somebody is harmed by it, that there's a backup plan, there's funding, there's monies to at least buy people out.
Right.
And so far, I don't hear that, and I'm not sure, am I missing something?
No, actually, you're bringing up a different subject. Mr. Goodman was talking about harm to customers through, go ahead.
But I'm a customer.
Right, we'll get to that in a second, because you're
Okay.
it's a different issue.
All
But
right.
you raised the second issue, which I'll address, but go
Okay.
ahead.
I don't want to bore people with a lot of regulatory stuff that you don't care to hear about, but I think to answer your question, just bear with me for a minute, and I'm also happy to talk more either after the procedural conference, or you can get my contact information also, and we can talk another day. But going back, with a comparison of fully regulated utilities, like I don't remember who the utilities out here, it's NYSEG or Niagara Mohawk. Those utilities, when I say fully regulated, they get their entire cost of service recovered from customers, along with an opportunity to earn a profit of, say, 8% or 10%, or whatever the percentage might be. For those companies, because they have the right to recover all their costs from utility customers, the Commission cares a great deal about the investments they're making, or the investments in maintenance and building a system, maintaining a system that will provide safe and reliable service. Because it's not about providing safe and reliable service, but are they being financially prudent? Are you getting that service at the best cost possible? So there's that concern about harm to captive, what are called captive ratepayers, who have no other choice than to get service from the utility. That financial harm of, is the utility being prudent and giving you a basically good deal for your investment, providing the service at the lowest cost they can. With the merchant generators like Cassadaga or Dunkirk or others, they don't have any right to recover costs from utility customers. They live and die by what they can make in the wholesale market, selling energy, capacity, and maybe some other products. As utility customers, we pay whatever we pay for the energy, but it's up to the wind the wind generator, the wind farm, or the natural gas fired generator, or the other generator, to run its business in a way that they can be profitable by operating in the market. So when I spoke about the commission in these types of petitions looking at harm to captive ratepayers, it's that financial harm. It's the harm of, is there going to be some direct financial impact to the utility ratepayer from this project? And because the merchant generator, again, has assumed all the risk of market operation, they can't recover their costs from customers, it's relatively uncommon for there to be that kind of harm to ratepayers from these transactions. There can be potential harm to ratepayers if the merchant generator can exercise market power, because that's a case where the merchant generator will be manipulating prices, and that's going to ultimately impact us because we're paying more for electricity. So that's my long-winded
Okay,
answer,
and
and
then-
I'm happy to talk more about it.
I would like
to your
to talk-
second issue, I
okay.
don't mean to talk over you, but just complete the answer. To your second issue of the other kinds of harm, we've heard about tonight from the operation of the wind turbines or from some of the other impacts it might have, that typically is outside the scope of review of the Section 70 Section 70, the transfer petition. I'm talking about myself. Section 70 petitions, like if you have a transfer of ownership, that type of harm is not usually looked at. In Section 68, as Judge Lecakes explained earlier, in other Section 68 proceedings, the Commission might take a broader view, potentially to look at things beyond, say, just financial harm. But because the Commission's review here was narrowed by the decision of a different decision-making body, I guess it's question. I don't know that they.
Well,
I don't know what we can.
And that's what I want to find out. Mr. Moscato, did the siting board look at liability insurance or any issue like that? Was that part of the application?
Yes, yes.
Like,
There were submissions based on, I believe it was also in Exhibit 14 with in the sections on cost. There was a discussion of that as well.
Mr. Wilmore, is that your recollection?
Yeah, there was something on, I believe, on insurance.
Okay. Speaking with Seth Wilmore, SETHWILMORE, for Cassadaga Wind LLC. I got your name right, correct?
Yeah.
What was days of hearings?
It sinks in, especially the room recollects it. But again, though, that would be within the parameters or the framework of Article 10. And so,
Right.
Any of those requirements or obligations would be on top of the obligations in Article 10. They would be things that were looked at and reviewed, and there was a decision.
Right,
made.
I absolutely appreciate that, and my recollection was that there was information in the application, but it has been a while, so if you could just point my attention to that, because I agree with Mr. Goodman that would normally fall under the Commission's purview under Section 68 look, and if the siting board's already done that, then I think it's been taken out of this case. If not, then I think that people would be entitled to review or to examine that further. Otherwise, I just would like to see what it is and where it existed in the application. We can review it that way and just let the Commission know, yes, the issue of liability insurance and indemnity and things like that have been looked at by the siting board.
Yeah, I think we have no problem trying to provide the information, especially if it's already in the Article 10 application or otherwise. I do think, though, that given the very narrow description of the Commission's authority for Cassadaga Wind, it may be different for future Article 10 proceedings. It may be different for future Section 68 proceedings. But the siting board did provide clear instruction, and to the extent that the Commission's decision here would impose new obligations on the construction or operation of the project, that seems afield from what the siting board said was within their purview on this petition.
Right, I'm not looking at it in terms of the Commission necessarily imposing new conditions on Cassadaga Wind LLC. What I'm looking at it as part of the review and determination of whether the company is solvent and financially viable to proceed with construction and operation of the project.
Thank you. That's a helpful clarification.
Your Honor,
Yes.
we were talking about maintenance and costs and things like that, reliability. This is a petition regarding Stony Creek wind project, and it was regarding a certificate for public need and whatever CPCN. And somebody had sent in evidence from the town of Orangeville, the Sheldon Wind Farm. It was an Inogy wind project that had been only running for 3 days of testing. The town of Orangeville and Inogy have completed construction, but the Sheldon Wind Farm project experienced 10 wind turbine serious blade failures. And that was within the 20-mile-an-hour winds and everything. But did you know that the wind companies are not even required to report fires, and you never read about these blade throws or blade breakage, and every wind project in New York State has had some really kind of catastrophic blade failure, and you don't hear about it because it's always kept under wraps. Big Wind doesn't want you to know. But anyways, one of the things I did find, because I didn't have my paper earlier, now I can't find it again, is just Mr. Moscato said in his letter that the project is economically feasible. Quote, income to support the project will be generated by the sale of energy pursuant to the executed offtake agreement and sale of green attributes to New England ISO. But really, we have such low production here, and like I said, 21 of these turbines are depicted in NRO mode if they comply with that. So that's curtailment there, less production, the BAT curtailment, and so I'm like, okay, so that's going to be part of the project support. That's scary because the PTCs are running out. That's why Res next door for Ball Wind is complaining they need to go 600 feet because they're all looking at the PTCs running out. In Europe, they're all freaked out, all the big wind people out there. They're like, oh, what are we going to do? How's this? Can we be financially viable when their PTCs are getting cut or whatever they have? They're in tariff in feeds or whatever in Europe, but they're losing all their subsidies. So they're saying we might not be able to be profitable within a couple of years. They're looking at 800-foot turbines to repurpose and repower their sites as a possible thing to make these projects viable. But they don't know if it'll work. They don't know if these 800-foot turbines will stand. So there's a lot of issues here.
Well, so you brought up a lot of issues.
I know.
And
There are a lot of issues.
But a lot of those issues have been dealt with in other areas of the siting board. For example, what happens if the project is built and the company finds it so uneconomically feasible that it stops operating it? And then there's a trigger for the decommissioning that kicks in on the siting board's order, and there's a very strong decommission policy that the siting board put in because it was very concerned about that issue. So that those funds would kick in, and the turbines would come down. And if I remember correctly, it was an instrument, a money instrument that is to be held by the towns. Isn't that correct?
Letter of credit held by the towns.
Yeah.
And that's only because we fought for that, because they weren't going to have any money in any decommissioning funding. They were not.
Right, so that issue has been dealt with. So then the issue about the constructing of the turbines and whether there's several failures or anything like that in the beginning, the only way that that's relevant to the case before the commission right now is, okay, if that happens, if you have a 50% failure rate, an 80% failure rate, does the company have enough money and the ability to finance through debt or otherwise improvements, repairs, and maintenance to those turbines? And we did talk about getting the maintenance costs in some way into the record in this case. So that is an issue that you did bring up that has some relevance in some ways, but it has already been dealt with in other ways by the commission. There is compliance filing, Mr. Moscato, that's required once the final turbine is selected, isn't that correct?
Correct.
All right.
There'll be final design plans submitted as compliance filing.
Right. So the way the compliance process works is, going back to, you mentioned Ms. Servin before, Cerbin, who is the attorney for Department of Public Staff, Service staff on the Article 10 process. So the compliance filing goes to her and her review staff, and they take a look at all the compliance filings, and they do a deep review in that to see, you know, is this a reputable company that's making these components, you know, what is the failure rate of the components and things like that. And they take a look at that, and if they have concerns, they raise them with Mr. Moscato, they raise them with the siting board, or when the siting board's jurisdiction expires, then the Public Service Commission does become responsible for reviewing those compliance filings. And then they make a recommendation, if they find an issue in that, they make a recommendation to either the siting board or the commission to reject that filing and say that it's not compliant with the requirements of the siting board's order.
Could I just say, one of my biggest concerns is they want to start the tree clearing, and they cannot be allowed to do that until they've selected that turbine model, done a thorough PNIA that we can review, and I know our attorney and our petition, who is working with our attorney, wants to meet with DPS and go over some of the terrible, post-construction compliance protocol. It's all about modeling and who can make complaints, and only if it's, if you're modeled to be over 40 decibels, will they even come look at your, do any kind of testing at your residence. But there's so many concerns, but we don't want to hear, oops, we took all these acres of trees out and guess we can't put the turbine there because it's not going to, meet compliance, or the soil's not right. They cannot be tree clearing until all the compliance conditions are met. That is part of construction. They'll argue, oh, that's not part of construction, but it is.
So, Mr. Moscato, you mentioned in your petition that you were seeking an expedited review, and you mentioned something that there were requirements of the siting board's order that the company had to meet, conditions that the company had to meet, and that was part of the reason seeking expedited review. Is that right?
No.
Okay.
The reason we sought expedited review is because under the Commission's precedent, construction of a project can't commence until the CPCN is issued. And the Commission has interpreted tree clearing as the commencement of construction in other contexts. The siting board may or may not have taken a different approach to that. I think that's an arguable point. I think the order is clear in its terms in Condition 13, but I think DPS staff has a different view of that. But that doesn't matter. I mean, for purposes of the CPCN, we have an understanding that there's a tree clearing window that has to take place from November to March. And if that tree clearing does not take place within that window, then it is inconsistent with the provisions of the siting board order that said in order to minimize impacts to bats, that tree clearing had to take place during that window.
Okay, that's the part of that refreshes my recollection of the petition. So you mentioned something along those lines, but it was less specific than that in the petition.
Correct.
Okay.
And so so to expand on that's the reason for the expedited proceeding, in that getting CPCN approval from the Commission, along with the compliance filings that'll necessitate or allow for tree clearing, would allow the tree clearing to commence in the time period prior to that March date.
Okay, and if the Commission did not issue a CPCN until March session or whatever, does that mean that the company then needs to wait until October of 2019 to start tree clearing?
I'm not certain, Your Honor. There are contingencies. DEC has guidelines for situations where tree clearing happens outside of that window.
Okay.
And so there may be protocols that would allow for addressing that situation. But as we sit here today, Your Honor, that's an eventuality that the company is hoping to avoid.
Okay, that's fair. I don't expect you to know every eventuality that could occur.
Your Honor?
Yes, Mr. Goodman.
It is DPS staff's position that tree clearing is construction and that it cannot begin until the developer has both the CPCN under Section 68 of the Public Service Law, and also whatever compliance filings required by, relevant compliance filings required under the Article 10 certificate have been approved. I don't know what those, I'm not on the Article 10 staff. I don't know what compliance filings are relevant to tree clearing, but my understanding is that the extent of the compliance filings touch on tree clearing, one of the things that those have to be reviewed and approved by the commission, in addition to receiving the Section 68 CPCN for tree clearing to commence. And I'll leave it at that.
Yeah, well, I believe the siting board still has jurisdiction over the compliance filings because of the rehearing petition, or has that expired now?
I believe the siting board's jurisdiction is expired now.
Okay, so it would be the commission then. So, but it still would be Andrea Servin and her group that would be looking at the compliance filings, right?
That's correct, Your Honor.
So the statement that you're making here is your understanding is reviewing this under the Section 68. Do we know if Ms. Servin and her group agrees that those compliance filings are required prior to the clearing of trees?
I have discussed this issue with Ms. Servin, and my understanding from talking to her was that there is at least one or more compliance filings required under the certificate for tree clearing to commence. Again, I do not know what the compliance filings are or what that status is. I am only aware that the tree clearing, the Section 68 CPCN is not sufficient authority for the developer to move forward with tree clearing.
Right.
That's one piece of it, and then there's at least one additional compliance filing they would need to have in hand approved by the commission before they can start tree clearing.
When you get back to the office, could you talk to Ms. Servin and clarify that? Because I bet you Mr. Moscato would like to know exactly what staff's expectations are on that. And as well as Ms. Riggle and all the residential parties would like to know what DPS staff, Department of Public Service staff, is viewing as the compliance filings that need to occur in addition to the CPCN approval prior to tree clearing taking place.
And I can tell you, Your Honor, from our understanding is that the order does not require compliance filings ahead of the tree clearing, that tree clearing was authorized by the order. Nevertheless, the company has had discussions with DPS staff about compliance filings that could be submitted in advance of tree clearing. The intent is to have those compliance filings submitted and reviewed by the siting board or the commission, and with DPS staff and the commission, and ultimately have those approved along with the CPCN so that tree clearing can timely commence.
I appreciate that. I think, though, there's two reasons I asked for. One is I think the residential parties have the right to know what DPS is looking at with regard to that. And the other thing is I would like to know so that, you know, when the commission, when it's discussed with the commission, I can let them know, you know, this is the effect of granting the CPCN now, this is the effect of denying it, or even if you grant it, it's still contingent on these other compliance filings being made. I think the commission would like to have that information available.
Your Honor, can I say something?
Yes, absolutely.
All this, like Joni said, is the cart before the horse. You want to clear thousands of acres, especially Botwell Hill and stuff like that, before anything is definite. So what happens? They go and they clear cut this whole area. It's all woods.
Right.
What happens if this falls through? Are they going to be responsible to replant?
Well, and that's why I think we can't speculate on that right now until we know exactly what DPS views as being the triggering conditions to allow Cassadaga Wind to go and start clearing trees. Because it depends on, the answer to that question changes based on what compliance filings DPS staff is looking for. So.
But neither. I mean, and I'm sorry to interrupt.
No, go ahead.
That doesn't seem to bear on the issuance of the CPCN regardless. Section 68 has a test. The siting board has outlined the specific inquiries that it wants the commission to take with respect to the CPCN for this facility. So I don't understand that inquiry as being, while I'm willing to participate in this, I don't see that as being directly relevant to the Section 68
CPCN issuance.
It's not directly relevant to the issuance of the CPCN. It's directly relevant to the expedited review that the company has asked for. And I think the commission, when it considers whether to grant expedited review versus considering other process, has the right to know what the effect is of granting the CPCN through expedited review versus taking a longer time to consider the case.
And Your Honor, as requested, I will talk to Ms. Servant and find out what compliance filings are, DPS staff believes are necessary for tree clearing. As requested, I'll update yourself and the parties with what I find out. And if it turns out that I misunderstood and there are no compliance filings relevant to the need, I'll let you know that as well.
Yeah,
and I
thank
do
you.
recognize, as you noted, that the compliance filings they're not part of this proceeding. It's just to the extent there's concern about tree clearing, it's a separate proceeding.
Again, in normal circumstances, I don't think they'd be related to this proceeding at all, other than the fact that we have a time window open to us, or that closes on us in a couple of months, and the company has requested expedited review because of that time window, and I think it's relevant information into the commission deciding whether expedited review is a good idea in this case or not.
I understand, Your Honor. I may not have spoken well about explaining it, but I understand that the process when we're talking about Article 10 or Section 68, we're throwing out a lot of sections of law. There's different proceedings or processes with different standards, and I know that it can be confusing for people within the agency to keep straight. I know if you don't deal with this all the time, it can also be confusing to keep straight. So I don't know that I actually clarified anything, but I was trying to just keep straight that this is the tree clearing issue is it goes to, as the judge said, the request for expedited review. However, when tree clearing can commence or whether it can commence is not really an issue in the scope of the Section 68 proceeding, except that they need that certificate at the end of the proceeding before they can go into tree clearing. I was just trying to help clarify the process.
Ms. Riggle?
With all due respect, if this Inogy company and their financial backing is so secure and wonderful, why should they be in such a hurry? Why are they so worried about the PTCs running out if they're in such financial good standing? I wonder why the rush, and it's just common sense not to clear trees until you've done all your compliance filings. That's, all I can say is we've seen Arkwright. They're going back now after the project is complete. They tried to sneak in a new request to the DEC and what's the other agency? Anyways, water. But anyways, they want to take out 5 more acres of trees, and we're like, what? Didn't you guys anticipate this when you designed this project? Why now? Now they're taking 5 more acres of trees out for the ROW, and like, that was this very poor planning and bad oversight, and that's what's scary. You see these chunks of your environment being hacked away. We live here. What about just common sense? I listen to all this legality and all the dotting the I's and the T's and legal precedents. What about just plain human decency and common sense?
Well,
it just gets,
Ms.
you
Riggle,
don't know what it's like to live here and see what's going on.
there's 2 things there. One is you brought up Arkwright, and it's been brought up a lot. I don't know anything about the conditions that were placed on an Arkwright certificate. I don't even, that process went through the old secret process. It didn't go through Article 10.
Much different.
It's the same order, Your Honor. It's the same order that did all the townships, so everything
But it
is
wasn't,
similar.
but it,
I know what you're saying. The same
but the restrictions that were put on by individual municipalities there are different than the one siting board deciding everything. And Mr. Spitzer, had his input into that a lot more than he had his input into this case. So, I mean, that's all I can say about that. The other issue, though, goes to the timing issue, and Ms. Riggle, what I heard Mr. Moscato say to address that is that the certificate conditions on the site board certificate require tree cutting to be done in a certain window so that it minimizes impacts to wildlife and other things like that. And to be able to hit that window and be able to perform in accordance with the certificate conditions without having to go to DEC and getting exceptions or anything like that, it would need to be done sooner rather than later, but that there are contingencies that may occur if the commission doesn't grant the expedited hearing. So I don't think it was an effort to rush things just to push it in the face of the residents as it was to try and comply with conditions imposed by the DEC arm of the Article 10 process.
Well, actually, his whole petition was all about, we won't, this is to make this project viable and to actually get our PTCs. He actually came out in 3 different spots, and that was the emphasis. We're going to lose our funding, so we got to push this through. That was the whole emphasis of his petition. We've got to get it done.
Is that
I have it right
part
here
of
if
the
you'd like to
emphasis
see
or
it.
all of the emphasis?
It was most of
Your
it.
Honor, I mean, as you know, having presided over the siting board
Right.
process, these are complicated projects. So it's 2 things. It's the window that I mentioned with respect to DEC. That's the specific time frame. The window that Ms. Riggle is talking about it's unrelated to the November to March time frame. That relates to a federal
In-service operation date?
Sorry.
Is it an in-service operation?
It's an in-service operation date that, so, for purposes of calculating November to March, I mean, we could go through a construction schedule if we had to, but it's a matter of ensuring that window, in order to qualify for under those requirements, is met in that time frame, and that time frame ends, what was it? December 31st of 2020.
Okay.
So, with respect to tree clearing, you can look at the time frame there, not the few months it takes for that effort. You can look at a 1 year to 18-month window for construction, and you can see that COD 2020 is rapidly approaching.
All right, I think I've heard everything I need. The way I understand it right now is I've heard the residential parties asking for an evidentiary hearing to consider issues that were raised in the public statement part of this process, and as well as what was discussed here at the procedural conference. I have Mr. Moscato's petition asking or waiving the right for the company to have an evidentiary hearing and asking that no evidentiary hearing beyond the public statement hearing be held. Mr. Goodman, does DPS staff have any position on process in this case, further process?
Your Honor, the department does not think that an evidentiary hearing is needed. Additional information will be provided, and if, to the extent we feel it's necessary, to have more information on the financial condition of the company, we think that it's adequate to go through discovery to get that information.
Okay, and all I would ask is, regardless of whether we have an evidentiary hearing or not, if there is any informal discovery that takes place between staff and the company, once those phone calls are concluded, and just for the residential parties' understanding, when I say informal discovery, what happens is a staff member will pick up the phone and call somebody, either Mr. Moscato or somebody for the company, and say, hey, do you have this financial information? And they say, well, we don't have that necessarily, but we have, something different that's like that will give you the same information. And then the person from staff will say, yeah, I think I can work with that, okay. And then what generally will happen is they'll email it over or something like that. It's a way of getting out of the sending a formal discovery question and then getting an answer back saying, no, we don't have that, and then sending out another discovery question. So that's the way informal discovery takes place, and it just basically zeroes in on the information that DPS staff feels they need. When you find out, Mr. Goodman, what that information is, even if you get it through an email, I would really appreciate it in this case if you would then send a formal discovery request, copy all the parties in it, and Mr. Moscato, if you would respond to that formally and copy the parties, I would appreciate that. And that way, everybody will know exactly what discovery has been asked by DPS and what information has been provided by the company.
We will do that, Your Honor.
Thank you.
Your Honor, can I just one additional
Yes.
thing with respect to you addressed confidentiality earlier, and you know we do want to be careful about confidential information. The previous protective order that was in place for the siting board, I do not believe would apply in this proceeding.
No, and I don't believe that the parties actually signed that. Some of them may have, but I don't believe all of them did. So I would have to come up with a new protective order in this proceeding.
Right. I was going to say let's cross that bridge when we come to it. I think that may be the better approach.
I agree with you. I think that I'm trying to think of my experience as counsel for the department when I did articles or Section 68 petitions. And I don't think I ever read a confidential filing once in those cases.
Just given the nature of the information we're talking about, there is the potential for it, but I do not believe it would be necessary.
Right. I don't think so either. I agree. We'll cross that bridge when we get to it and deal with it as we need to. Ms. Riggle?
I was just going to ask if we could participate in the discovery process here.
Yes, absolutely. So you're allowed to ask discovery questions. However, it needs to be relevant to the issues, so it would have to go to the financial viability under the Section 68 review. What I would appreciate you doing is, to the extent that you can, either talk to Mr. Goodman or Mr. Moscato first before you send out a written discovery question. And if there's a disagreement between you about whether it's relevant or not, or any other question about the discovery, give me a call, and I would be happy to mediate that between you.
Your Honor,
Go ahead, Mr.
okay. I have no objection to any party conducting discovery. I do have a question about process, though. There was a request for a decision to be made at the October session, correct?
Yes.
Ms. Scott?
Yes.
So we would have limited time now for the discovery, just given the time it would also take to prepare an item and for the commission to review what has been recommended. So I would just ask that if you do have questions, if we could get to them very soon. And Your Honor, I don't know what a deadline for the end of discovery would be, but I would ask if we could try to limit the amount of time the discovery will be, if only so that we don't keep it open-ended. And I know that at some point we have finality and staff can develop the recommendation to advance to the commission rather than worrying about whether there's still discovery potentially coming in.
Right. No, I appreciate that, and I do understand that. And both Commissioner Berman and I are aware of the request made for the session, but we need neither of us feel bound by that request to grant it.
I understand.
I mean, it may be, but it may not be. I mean, it depends on what issues get flagged. So.
I understand that, Your Honor. The department staff, to be so clear, we don't feel bound by the request. For any time there's a petition under sections 68, 69, 70, if there's a request for a decision by a particular time, the department staff tries to work to get a position to accommodate that. We never feel bound to oblige the request. And just for whatever it's worth to clarify, in terms of talking about the questions that were submitted, from my perspective, that's more efficient to try to, again, to the judge's point about all the back and forth, which can take time for submitting paper or email. Sometimes in a telephone conversation, we can work through it more quickly to get to the question, and the applicant that's then responding can get right on.
Right. The one thing I would say, Mr. Goodman, is yes, I agree with you that when staff receive a petition like this, it normally tries to meet the request of the person asking for good reason, because it's usually asked for reasons that the company needs a decision by a certain date. In this case, I am very sensitive, and I'm sure Commissioner Berman is very sensitive to the fact that many people reminded us that this was the first Article 10 certificate granted in this state. So,
I I understand, Your Honor, and I was here all evening. I heard the concerns. I understand that this is not a project. I understand the concerns, and you know, we're not attempting to ram this Section 68 certificate. We are doing the standard review that staff typically do on a petition.
Right, and the only thing I'm trying to do, and I understand that, having worked at your job before I became the judge, is in this case, what I really think is necessary is to have that open to more parties than we traditionally have it open to, because nobody generally cares often in other cases as to these Section 68 petitions. And in this case, we have people who have participated from, 2 years ago in this case.
I understand.
Your Honor, can I say one more thing?
Yes, you may.
I want to read a little bit here. We need a new evidentiary hearing to prove Cassadaga Wind has long-term reliability, stability, and financial assets to carry through with this franchise. So it seems like Mr. Moscato has all the information on the company and stuff like that. We need this hearing for him and his company to prove to us what's going on and long-term. So we don't have to rush and start tree clearing in November. Tree clear, think about it next year, 2019. If they're so strong and they have so much money, so we wait. Things get missed when you rush and you try to ram it down people's throats. Things get missed and overlooked, and you can't take a lot of things back.
I appreciate that. The only thing I'll say is you don't necessarily need an evidentiary hearing for that. What you're right about is you need that evidence to be in the record, and there are ways of getting in the record without necessarily having an evidentiary hearing. It may be that we need an evidentiary hearing, but generally you only need an evidentiary hearing when the evidence that's provided through discovery or however else is contested, and there's a reason to doubt the truth of that evidence, and need to be subject to that evidence to cross-examination or other testimony. And I'm not sure yet that we're there. It depends on what evidence staff believes it needs to review this petition and what it shares with the residential parties. So, like I said, I'm not prepared to make a ruling tonight, but I do expect to make one fairly quickly as to additional process in this case.
Your Honor, can I be heard?
Yes, Mr. Moscato.
With respect to discovery, we believe that we would object to open-ended discovery in this case. We do not believe that the participants, the parties in this case, have raised any issues for adjudication. The issues that have been discussed tonight have been, at best, we can tell, conflicting. They don't even conflict statements that were made in the petition. They just repeat things that may be in financial analysis or other press reports. That it wouldn't rise to the level of evidence which would result in an issue in dispute in this proceeding. And so my concern is now we've prejudged whether or not there's an issue in dispute. We've granted party status without a finding of an issue in dispute. And we've gone beyond what, one, the citing board has ordered the commission to review within its purview under the Article 10 order. And two, we've gone well beyond any Section 68 precedent on a wind farm or any other project that I've been involved with. The Section 68 regulations and the hearing, the hearing requirements, I can't think of an adjudicatory proceeding that has happened on a Section 68 project. The review and inquiry that you've suggested that the applicant allow the intervener parties to conduct could amount to potentially a fishing expedition on financial information that goes well beyond what the commission's purview would generally be for wholesale electric generators lightly regulated under the public service law. So I guess I have concerns that we jumped way ahead without discussing the actual issues in dispute, having those issues identified, whether there was any evidence that would actually substantiate those issues, and granted party status on matters where there were no genuine issues in dispute.
Well, I think that the issues that were brought up in dispute is that we're not in dispute necessarily, but the issue that is confronting us is there enough information in the record for staff to do its normal review and for the interveners to have looked at that evidence to be comfortable with the fact that they understand what staff's review is in this case. And that, again, is very narrow as far as I see it. That's why I've asked Mr. Goodman to any questions that would normally be done through informal story or through phone calls from staff would go to you, and also that the interveners, if they had any questions that they thought they might want to ask of the company, to talk to either Mr. Goodman or you first, and if there was any question about what they were asking, whether that information was pertinent or relevant to this case, then you give me a call immediately. I will note that Mr. Goodman did ask earlier in this proceeding, or in this procedural conference tonight, to put a deadline on discovery, and noted the October session that has been asked for in the Cassadaga Wind petition. So I'm aware of all of that information. So.
Your Honor, we would, just so it's clear for the record, we would join the request to have a date at a minimum, to the extent that discovery is allowed, that we would have a date to close discovery.
I appreciate that.
Yes, Your Honor, and with all due respect, none of us in this room tonight have ever been through an Article 10 procedure before, and it demands the absolute highest standard of discovery, consideration, and adjudication.
Right, no, and I appreciate that when you say none of us in this room, it's a fact that none of us in this room, including myself, that we are at the forefront of this. I do appreciate that. So.
Well, I would just disagree in one respect. Section 68s on wind farm projects are not new in New York.
No.
We have 1,700 megawatts of operating wind farm projects in New York.
Right.
So,
no, they are not new. You are correct about that. But Article 10 and how it fits within the Commission's review process and things like that, it is somewhat groundbreaking here.
I would have said narrower, but that's fine too. Groundbreaking is, I understand.
Your Honor, that's a point I wanted to ask, is I'm a little perplexed. Who came up with this rule that PSL 68 is, cannot be duplicative of Article 10? The siting board, who is, has a definite bias. I mean, they're
No, the New York State Legislature.
Okay, really?
Yeah, the ones who the ones who.
I would like to see that documentation that says that there cannot be any overlap, or.
No, it's the Article 10 laws, the Public Service Law Article 10 versus the Public Service Law Section 68.
Right, but where specifically does Article 10 state that there could be no, other than the siting board, stating that, where does the Article 10 itself, the law?
I don't have the reference offhand, Mr. Moscato.
I'm sorry, Your Honor.
Hey, that's okay. Ms. Riggle was just asking about where the preemption authority of the siting board is found in Article 10, and I'm just drawing the blank. Do you know offhand?
I believe it's in Section 172 of the Public Service Law.
Okay. Thank you.
And I guess I'd just close with saying, I think, we would definitely like an evidentiary hearing. I think just the fact that there was a gross omission on the petition from Cassadaga Wind about any of what's going on in the German market and this huge transition with RWE and Eon and Inogy, and he can make it sound like it's a bunch of baloney, like we don't know what we're talking about. Of course, I'm not a lawyer. I'm not sophisticated. This is very difficult and time consuming, but all you have to do is look online for 10 minutes and you can find all kinds of financial reports from the bigwig, investors in Europe and Germany. I think they know a lot more about it than we probably do sitting at this table.
But they're looking at it with a different viewpoint and providing information to a different audience than a regulatory body and for different purposes. There's a whole lot there.
They're concerned about their projects in the UK and all their projects, so I think it'll be a trickle-down effect here. If they're struggling in Europe, they're going to be, there'll be fallout here. So, I mean,
I appreciate that.
The burden of proof should be on Cassadaga Wind to prove the finances. We want to see it.
Speculative articles found on the internet are not enough to raise an issue of fact against evidence of it just,
But the investors, who's going to want to invest in these shaky companies? There's been so much bankruptcy, and it's,
but those are different issues than the actual financial viability of the corporation to access debt to finance the construction and operation of a project. So it's,
difficult to hear.
This is, Your Honor, this is my concern with
I
respect to
understand.
relevancy issues on discovery.
and that's why I don't hesitate to get me involved if there's a concern or question about something that's being asked. All right. With that, I will not make any ruling tonight, but I expect to issue a ruling in writing as to any further process that's necessary for this case. It is 10:10 p.m. and Mr. Scott.
Just really quickly, Your Honor, just so I have it clear in my notes, we understand that we're going to look in Exhibit 14 to see if there's cost information on typical maintenance for a period of time. We were also going to look to see the Exhibit 14 in the Article 10 application, whether there's insurance information. Those are the two immediate information needs that were requested of us, and we will try to provide that information very
As soon
soon.
as possible.
If not, I would say in the next day or so.
That would be appreciated. Those are the only two requests that I've made.
Your Honor, can I add to that, to the maintenance? Instead of doing first-year maintenance, which might be low, how about like 2, 3, 5-year maintenance when you have major components that need to be replaced?
Well, I think what was asked for was any maintenance costs that were in the Article 10 application, and if those don't exist, then some representative sample of an expected maintenance cost during the lifetime of the project on an annual basis.
First year just very
Right. All right, with that, I think we are done, and we are off the record. Thank you, everyone.
Thank you. Have a good night. Thank you.
It's more of us. Everybody outside seems like